Chairman, honorable members of the committee, my name is Mark Meckler. I'm the president of Convention of States Action. We are the national group that is responsible for helping to move this initiative forward all across the country. I've had the great honor of traveling the country. I've been in 48 states and the legislatures in most of those states. And I will tell you, being in those legislatures, being here in Montana today is what actually is the only thing giving me hope for our nation today. The state legislatures are filled with real public servants, people who are here for the right reasons, not for money, not for fame, not for power, but because they care about their states. And they've taken an oath to their state constitution and the United States Constitution. Today in America, all of that is at stake. I think people agree with this regardless of what side of the aisle they're on. We're seeing incredible division, perhaps the greatest division we've ever seen in modern America. And everybody, regardless of the side of the aisle or the political ideology, is concerned about what's going on in the country today. I'm here to tell you that the only solution that I'm aware of today in the United States of America that can solve the big problems facing our country is Article 5. Our problem is we're so divided as a nation, and we do everything or so many things in Washington, D.C. Roughly 60 to 65% of your state budget is controlled in Washington, D.C. And with a divided nation, what that means is roughly 50% of us are always angry about what's going on in Washington, D.C. The founders had a solution for this. They called it Article 5. The founders told us back in 1787 that if we got to the point where we felt like the federal government was doing too much, was too involved, was too tyrannical, not by party, but by institution in Washington, D.C., that we should call an Article 5 convention and we should take our power back. We should return it to the states. People are concerned, and rightly concerned, that we live in a nation where people don't really like each other, but the true history of our country is we haven't always really liked each other. In 1787, we joined together because we fought a common foe, but you move forward through history, we fought a civil war, we've always disliked and distrusted each other between states, and the only thing that made it work is that we had a federal government that was designed to do a limited amount of enumerated things, the things that we believed that we had to do together in a dangerous world to be successful as a nation. Today, the federal government has far exceeded those bounds. And regardless of party, we are frustrated by Washington, D.C. But we do have the power, you have the power to do something extraordinary. You, as state legislators, are extraordinarily imbued with power. You're not told this when you get your orientation here, but you are the only people in the federal government with the power to call a convention, to propose amendments, and to ratify those amendments, thereby restructuring the United States government and bringing the power back to the people in the states. Why you? Why were state legislators given this power? And I think the answer is obvious when you look at history, because those who served in the convention in 1787 were state legislators. They served in state legislatures, colonial legislatures. They served on town councils and county boards. So why did the founders give them the power? Why them and not somebody in Congress? And the reason is because the founders didn't trust you any more than they trusted people who would be in Congress. They understood human frailty and human flaws and human nature better than almost anybody. What they did is they trusted people more who were close to the people that they governed. Nowhere is this more true than in the Montana legislature. You go home and you live with your constituents. You live the same lives that they do. You're not insulated from them. You're not separated from them. They can come here and see you here. They can see you at home. And they do see you at home. In church, on the ball field, in service organizations. And the founders knew that someday the federal government would grow out of control and it would take state legislators to step up to the plate and rein it in. And that's what we're asking you to do today. In summary, one of the things you're going to hear that there's going to be a runaway convention, and we are going to lose our government if we allow there to be a convention. It's very important that you understand two things. One, we've lost our government. If you think you have any control over what goes on in Washington, D.C. today, the control is the other way around. They control us as individuals, and they control your state, 60 to 65% of your budget. Number two, and equally important, the idea of a runaway convention is a fallacy. It's actually a fallacy that was invented in the 1970s by the radical left to stop conservatives who were trying to do important things to limit the growth of federal government. And you don't have to believe me. This is all on our website. Read David Horowitz's article about this. He's the great scholar of the American left. It's also important to remember who supports this and who doesn't support this. Because sometimes I can't know the politics of everything, so I just look to who supports it. Every major conservative figure in the United States of America who's commented on this, all the talking heads, Limbaugh, Levin, Shapiro, Hannity, are all in favor. All the scholars, Randy Barnett, Robbie George, and right here from Montana, Rob Natelson. And on the other side, is frankly every radical left-wing group in America signed a press release approximately 4 years ago against Convention of States. So I'll close with that. The idea is that you have to choose a side at this point. And you have to make your choice between Montana or the federal government in Washington, D.C. I'm here to tell you that I choose Montana, and I hope that you will choose to support SJR 2. Thank you for your time.
Senator Friedel.
Thank you, Chairman. This question will be directed toward two people. The first one will be Mr. Meckler.
Mr. Chairman, Senator Friedel.
Thank you for showing up today. I have a question, and I've been I think this may be the question that may decide which way to go, and I think this may help out both sides. So I'm going to give this opportunity to you, sir, as well as Mr. Brown, to see what your guys' answers are to it. Does that make sense?
Yes, sir.
Thank you, sir. Thank you for the leeway. What stops the federal legislation, knowing that they use the decisions that have been handed down by the United States Supreme Court, examples such as Roe v. Wade, the Interstate Commerce Act, these like there's of. What stops them from excuse me, I apologize. I'm trying to read my chicken from scratch. I apologize. Never corrected it since college. I hate it. What stops them from taking this type of information, knowing that they sit on their laurels of using interstate commerce, Roe versus Wade? These Supreme Court decisions are, quote, part of the law of the land almost at this point, and not using the barriers, the guardrails of the Constitution itself, the 28. What stops them from, after a convention of states is called, that the federal legislators themselves wouldn't use the Supreme Court to usurp the authority we think we have or we may have in the aspects of the Article 5 to say, no, you only have the ability to call said, and then actually ultimately give the federal legislators the authority to start playing with our Constitution. Does that make sense?
I'm confused by the question, so let me try to restate it and see if I understand you and make sure that I'm answering you correctly. Your question in regard to Congress getting engaged in the management of the convention itself and what's done and said and discussed at the convention, or is it a discussion about whether Congress will follow amendments that come out of convention and are duly ratified?
More on the, I apologize for the confusion. It was more on the fact that once a convention of states is called, that they couldn't use the Supreme Court to make a decision that the federal government would have ultimate authority over said convention, giving them basically full authority over it, allowing them to do what supposedly the Article 5 gives us as a state.
Right, and I appreciate the question, Senator. I believe I understand you now. What we're talking about is the authority of the convention independent of the United States Congress. And the answer to that is both constitutional, historical, and common sense. On the constitutional level, the word call at the time of 1787 actually had a legal meaning. And it meant literally to name the time and place. And in fact, the United States Constitution limits the duties and responsibilities of Congress in regard to said convention to naming the time and place. Those are the only responsibilities. From a legal perspective, I will tell you, words matter. The Constitution is their words, they're the ultimate legal doctrine of the land. I think it's really important that when we look into these matters that we consult people who are experts in those things. I'm a constitutional attorney. I've been a practicing attorney since 1988. Rob Nadelson from your state is the greatest authority on this. He was a professor at University of Montana Law for 26 years. And those are the kinds of things that I rely upon. So if you go back to the history of convention, when this provision was added to the Constitution, it was specifically added to give the states and the citizens thereof a way to route around the authority of Congress. To propose that the founders intended or somehow mistakenly drafted the second provision of Article 5, which would give Congress control, would actually make the second clause of Article 5 completely redundant. In other words, Congress already controls the ability to propose amendments on their own whenever 2/3 of each house shall so propose, and then go out for ratification by the same methods as a convention proposed amendment would go out. So the proposition that Congress somehow controls, according to the Constitution itself, would literally make the second clause of Article 5 redundant and irrelevant. It would simply be stricken from the Constitution. As a matter of common sense, it's important to note, during the convention in 1787, the very reason given by Colonel George Mason for putting the second clause of Article 5 into the Constitution, and Mason, by the way, spoke the second most of any of the founding fathers at the convention. He said that the reason was it was imperative that we gave the states power to propose amendments that the federal government would not. So again, imagine Mason standing to address the convention, saying those words, and actually meaning, but we're going to give all control to Congress exactly as they have if they propose amendments themselves. So as an originalist, as a textualist, as what I describe as a contextualist, understanding the text in the times and in the circumstances, it would be ridiculous for the founders to have drafted a clause of the Constitution that's completely redundant and irrelevant. We know this as a matter of history, too. If you look at the history of conventions throughout the United States, there have been a lot of conventions. And the opponents will say, we have no idea what will happen in convention, there's no law, there's no case law, there's no precedent. The truth is, there were 11 interstate conventions before 1787. There have been some 30 since. Now, to be fair, they were not Article 5 conventions called under Article 5 of the Constitution. But these were interstate conventions. These very similar rule sets to the 1787 convention. And the truth is that none of them have been controlled by outside bodies. The states commission their commissioners. They send them to their conventions with a limited amount of authority. They let the commissioners do their work. The commissioners make suggestions, as they would do in this convention, in an Article 5 amending convention, and then they follow the process. That's our history in the United States of America.
Thank you. A follow-up question, Chairman?
Go ahead.
Now, Mr. Meckler, and I do this, as I said, I appreciate your information, and I agree with you a lot of in the intent and in what they say in our Constitution and what they mean by it. The reason I say this is one of the things I have to say, the reason I'm going to this aspect is you understand the Second Amendment. You understand what it means fully, correct? Thou shalt not infringe. So we're perfectly clear. What it says in there, that without a doubt, with all the scholars, we know exactly what the Second Amendment means. Thou shalt not infringe. In fact, the whole point of the Constitution is, in the Bill of Rights, is to say, these are the things you cannot touch, government, correct?
Agreed.
Yet we still make laws about permitless carry. We still make laws about what we can say as far as speech, like say, for instance, yelling fire, fire in a confined area, even though that is freedom of speech, and I'm allowed to say that there obviously are consequences, but yet we still make laws that kind of dance around the Constitution. And my concern is that even though it says what it says in the Article 5, and I've read it several times like yourself, and I believe that you understand exactly what we're talking about, but the fact is the question I have is, knowing that what's in the Constitution, and we've seen what they've done, and in fact there was a large book that I was presented to see of all the decisions made by the federal Supreme Court that danced around things like for instance, like the interstate commerce. Clearly not in the Constitution, but yet we've danced around these these issues. Is it not a possibility or a probability of being at best that it's possible the United States Supreme Court may dance around the Article 5 just enough that say, well, it doesn't necessarily not say it, that they can start playing games like they've done, obviously, over the last 230 years? And that's my question.
Well, I want to make a distinction because I think you're actually, maybe not intentionally, but I believe you're asking two separate questions. First, you're asking about the Supreme Court ruling on the legislative authority, the constitutionality of legislation promulgated by Congress. That's one, because the book I showed you last night was the Constitution as produced by the federal government, annotated, including all cases ever issued by the United States Supreme Court. Those are rulings of the United States Supreme Court on laws drafted by Congress and elsewhere, sometimes laws drafted by the states. And so I guess I'm going to ask the first question, which is, does the Supreme Court get it wrong sometimes when dealing with the constitutionality or not of laws drafted by the federal legislature? And the answer is yes.
Yes.
Regularly. And in fact, the Second Amendment, which you discussed, I believe to be one of the most clear, shall not infringe. I think all of us understand what shall not infringe means. And yet the legislatures have been allowed to infringe. And so I think absolutely that Congress infringes. Congress does things it's not allowed to do constitutionally, and sometimes the Supreme Court supports that. The amazing thing is the founders gave us the remedy for that. The founders told us that when Congress does something like that and the courts allow it, we are to propose and ratify an amendment reining the court in. We know this, the 11th Amendment, most of the founders were alive when the 11th Amendment was drafted. The 11th Amendment, it's arcane. Most people don't know about it. I know about it because I'm a constitutional lawyer. I don't expect most people to know about it. But basically, there was a fight that took place over jurisdiction between the Supreme Court and Congress. And the Supreme Court took jurisdiction that Congress and the founders didn't want them to have. The founders immediately proposed and ratified an amendment limiting the Supreme Court's jurisdiction. So I think the lesson that we should draw from all of this is that we have power over the Supreme Court, not the other way around, and that our power is actually a constitutional power given to us by the founders, and that we should exercise that power over the Supreme Court. So I don't say that the Supreme Court has power over us. To the contrary, by using Article 5, the power we've been given, we actually have the ultimate power over the Supreme Court.
Thank you. I had to say I agree. I wish we would really tell our legislators follow the Constitution.
Senator
Thank you.
Manzella, you have a question?
Talked about this some today, but how do we know that, that a runaway convention is not possible? Can you talk about that a little more?
Sure. I mean, we know it, first of all, by history. We've had, as I said, 40 conventions throughout American history. There's no evidence of a runaway convention in all of American history. Some people will tell you that 1787 was a runaway convention. We've had testimony on that today. If you look at the commissions of all the folks who attended the convention, all of them had full authority to take any and all actions necessary for the exigencies of the Union, with the exception of New York and Massachusetts. They sent their delegations, didn't sign on. So we have a long history here throughout the United States of America. It's never been a convention of states between the states that ran away in any way or exceeded their mandate. The second reason is if you look at the process set out by the founders, in fact, were genius on process. We love what they did in the Constitution because they set forth a system of checks and balances. It's process, it's systemic. And they did the same thing in the idea of a convention of states. The way Convention of States works, and the chairman just asked the question about all the resolutions being the same, that means by the time that you get to convention, 34 states, which is a supermajority, have agreed on what I would describe as the law of convention, or the rails upon which convention must run. So you're going to send your commissioners, all the commissioners agree what the convention is about. Now, all states can attend. There will be likely 50 states in attendance, so there's 16 that might not have agreed to that, but a supermajority has agreed. When you pick your delegates, as you will, Congress will not pick your delegates. That's absurd in a federalist system. You'll pick your own commissioners or delegates, and you will send them with what's called a commission, which is a document that specifies what their actual authority is in convention, what they may or may not do. You retain absolute authority over your delegations in convention because you have appointed them. And, I understand that Mr. Brown's not a lawyer. This is simple law of agency. It doesn't even require a knowledge of the Constitution. When you appoint an agent to act on your behalf, the agent only has the authority with which you imbue them. So this is simple law of agency. It's true in common law in every state in the United States, at the federal level, and frankly, every country in the Western world. So you're going to send your delegates or your commissioners to the convention, and you control them. While they're there, because we now live in a technological universe, you will be in constant contact with them. You'll be watching them on a live video feed as to what they do, and you will be able, as a state legislature, to control their actions. Should a delegate do something you don't approve of, you'll be able to immediately withdraw their credentials, put in an alternate delegate, and draw them home if you so desire. This is true for all the states. In convention, it will take a minimum of 26 states or a simple majority to pass something that they consider should be a suggestion to the states, an amendment. So this is another part of the protective process. It takes a majority of states to propose and pass a resolution for an amendment out of Congress. Important to remember that out of the convention. It's important to remember what comes out of convention has no authority. It's simply a suggestion to the states that they ought to consider this. I can tell you my entire life, I've never watched a meeting and been terrified that they might suggest something. A suggestion is just that. Then it goes out to the states for ratification. It takes 38 states to ratify anything that comes out of convention. There's been some suggestion that the convention could modify the numbers necessary for ratification. Again, it shows that the people who are testifying to this are not lawyers and they have no real understanding of the law that's contained in the Constitution, because the Constitution itself specifies the number of states that must ratify it. And it's 3/4 of states. That indeed, by the way, could be amended ultimately if you were to hold a convention that is a separate convention to propose changing the ratifying number. But in this convention, you could not do that. So it would go out to the states for ratification. It would take a full 3/4 of states to ratify anything. And this is one of the things that I think is so important on a bipartisan basis or ideological spectrum basis. It is impossible to get anything ratified by 3/4 of states, 38 states, that is not widely agreed upon by the American people. It takes only 13 states to prevent the ratification of any amendment proposed by the convention.
Thank you, Mr. Chairman and members of the committee, for your indulgence for a long hearing and many testimony of many patriots. I appreciate the proponents and the opponents who testified today. I think it's very clear that they all have deep concern about the delicate and the critical situation of our union. I do want to address a few things that were said by opponents that were not addressed by any of the persons that were called up. One of the things that were mentioned was that Congress can control this convention. That is simply not the fact. Of course, the first reason we know that they can't control the convention is because of the paired powers of Article 5. So Article 5 gave Congress the ability to propose amendments, and they gave the states the ability to propose amendments through convention. The paired power is the founders knew that there would be a time when Congress would be tyrants and the states would need to step forward to propose amendments. So if we think that through any clause or idea that the founders envisioned that Congress could control the Article 5 process of proposing amendments under state conventions of states, then we would assume a certain amount of stupidity on the part of Congress. So they paired those powers so the states could have control over the amendment process, just as Congress has control when they propose amendments. There is a U.S. Senator named Sam Ervin, who in the 1960s tried 3 times to propose legislation that would enable Congress to propose amendments, or not to propose amendments, but to control the conventions. Those congressional bills were all defeated, and others. So we've seen this before. We've seen Congress try to control it. They've tried to bring bills for it, trying to control it, and that's all gone by the wayside. So we have extreme confidence that Congress will have no control. Another thing that was brought up, that states like New York would have multiple votes over states like Montana, or that the Electoral College would be the way that they would vote. That's simply not true. All conventions of states had one state, one vote. So Montana is an equal sovereign at the Convention of States, and we will have just as much weight with our vote as with the state of California. I bristle every time opponents use the word con or constitutional convention. That is fallacious. It is not right, because Article 5 does not give the power for a constitutional convention. Simply gives power for an Article 5 conventions of states. Even Article 5 itself limits what we can propose in amendments. It says you can't touch state sovereignty. It talks about Article 1, Section 9, I think, of Article 2, Section 9, I think, of the U.S. Constitution, like slavery. They couldn't mess with that, and they couldn't mess with other state issues. So even Article 5 limits what conventions can bring about. Another thing that was brought up that I think is seriously flawed is that none of the founders said that the Philadelphia Convention had authority to do what they did. That is completely false. All you need to do today is go read Federalist 40. Madison spends all of Federalist 40 saying that they did have the authority to propose the convention as it was done in 1787 in Philadelphia. So that's fallacious. John Marshall at the Virginia Ratification Convention said, many gentlemen have already said that we had the authority to do what we did in Philadelphia. So many founders did say that the people at the Philadelphia Convention had full authority to do what they said. All that Mr. Brown and his associates are doing is quoting anti-federalists. It's like us coming here today and someone saying the only thing brought up is what the proponent said and not what the opponent said. The anti-federalists had many things that they said, and the federalists had many things they said. What Mr. Brown says is only what the anti-federalists were saying, not what the federalists were saying. He was just bringing one side of the argument. Then this other argument that that the conventions can do anything they want is ludicrous. Even the Montana Constitutional Convention was limited. When the Montana Constitutional Convention tried to appropriate money for education, the court struck them down and slapped them down and said, you can't do that, that's not in your enabling act. So conventions are simply bound by their enabling acts, by their commissions, and by their limited application. Another thing that was brought up was this letter by Madison to Tuberville in 1787. Madison actually wrote that letter before the Constitution was even ratified. That is totally taken out of context. Madison wrote the letter was basically saying, we ought to ratify this first and give it some trial before we start having another convention. So that letter is taken out of context. Madison wrote it before the Constitutional Convention was even ratified. So, Mr. Chairman, I would just encourage us to not listen to the fearmongers. All the opponents have to do is say they're just naysayers. We are offering a constitutional, well-thought-out, extremely well-researched option for us to rein in the abuse of the federal government. I put on all of your packets today the Jefferson Statement. I would encourage you to read that. This is a statement from the top constitutional scholars in the United States of America. They have all agreed that the Convention of States is a legitimate constitutional process for us to pursue to remedy our problems. I also want to finally bring up, before I close with a couple of quotes from the founders, is what Robert Brown, and this was one of Senator Manzella's questions, about one of the articles or one of the potential amendments that was brought up at the 2016 Convention of States Simulated Convention. I'm going to read it to you, and I'm going to ask each one in this committee if they wouldn't support this. It says, the legislatures of the states shall have authority to abrogate any provision of federal law issued by the Congress, President, or administrative agencies of the United States, whether in the form of statute, decree, order, regulation, rule, opinion, decision, or other form. Such abrogation shall be effective when the legislatures of 3/5 of the state approve a resolution declaring the same provision or provisions of the federal law to be abrogated. I would submit that every one of us in this room would support that amendment. That is to say that, for example, when the ACA was passed, maybe not Senator Bennett, or I don't know, but when the ACA was passed, if 3/5 of the states could have had the ability to abrogate that law, it would be done. That would never have happened to us. This was a well-thought-out, drafted amendment. And by the way, this is just a suggestion. You still have to ratify with 38 states. Finally, Mr. Chairman, I just want to reiterate just a little bit that the United States of America is deficit spending or printing 47 cents of every dollar they spend. There are some simple, universal truths. Number one universal truth: you cannot outspend your income indefinitely without dire consequences. The borrower will be servant to the lender. John Cogan, in a book he recently wrote called The High Cost of Good Intentions, suggested that whether we had a president that was a Republican, a Democrat, a Congress that was controlled by Democrat or Republicans, whether we had a lot of money or a little money, that every one of those situations we have advanced the entitlement state. I blame Republicans as much as Democrats. And as a matter of fact, Republicans are historically worse than Democrats in deficit spending. So if you think that we are going to elect Republicans to control deficit spending, you're living on the wrong planet, because it's not going to happen on this planet. There's a second universal truth. Absolute power corrupts absolutely. And Washington is hopelessly corrupt. And we need to rein in the power and the jurisdiction of the federal government. And this Article 5 solution is a well thought out, constitutional, well-researched. I don't know of a better researched proposition by constitutional scholars in America than this one. Finally, James Madison said this. This was a letter in 1930. Amendments, therefore, will be necessary. It would be improper to require the consent of the national government or legislature, because they may abuse their power and refuse their consent on that very account. Then he said in Federalist 43, it, Article 5, moreover, equally enables the general and the state governments to originate the amendment of errors as they may be pointed out by the experience on one side or the other. So Madison pointed out that the federal government can propose amendments and the states can. It was a legitimate function of the state. Finally, I want to bring your attention to what our President Ronald Reagan said in his 1984 State of the Union address. He said this: we cannot depend on Congress to discipline itself. We must rely on the states to force Congress to act on our amendment. He was talking about a balanced budget amendment. Fortunately, our nation's founders gave us the means to amend the Constitution through the action of state legislatures. This is the only strategy that will work. Ronald Reagan, 1984 State of the Union Address. Members of the committee, I beg your due pass. Thank you.
I'm here live in Philadelphia at the Tomb of the Unknown Soldier. When you hear the phrase lives, fortunes, and sacred honor, these are the folks we should think of, those who anonymously gave their lives. Well, today you have a chance to volunteer. You need to volunteer for conventionofstates.com, the movement that's going to save the country. These folks are willing to step up and give everything. We need you to give just a little bit. Go to